seated. All right, we have two cases on our oral argument docket this afternoon. We'll take them in the order in which they were published. The first case is case number 24-1319, AK Land Title versus Hurd. Appellant's counsel, if you're ready.
Thank you, Your Honor. May it please the court. Jessica Scholl on behalf of Appellant AK Land. I would like to reserve 3 minutes for rebuttal, please.
Noted.
There are a number of reasons that this court should reverse the trial court's holding that all of Lot B is encumbered by an easement and that AK Land cannot build a home on the property. I'd like to focus today on the first question, which is the threshold question, and I believe is dispositive in this case, and that is that no easement was ever created. Mr. Hurd cannot meet his burden of proof to demonstrate a valid easement was ever created because not all of the owners of Lot B signed the easement, and the owners who did not do so pursuant to a power of attorney. Lot B is owned or was owned by 4 couples, and only 2 of those 8 owners executed restrictive covenants in the First Edition neighborhood.
And why didn't they have authority to do that from all 8, according to a power of attorney? And then we get into, I guess, the way that all 8 of them treated that disputed easement for the next couple of decades.
Sure. Even if there was a power of attorney that granted them the right to encumber the property, which there was not. There was a power of attorney that granted the right to sell and convey the property, and that was a specific grant of authority, not a general grant. So that's very strictly construed, and the court can't expand the powers of that. They're bound to the powers of that. But they did not sign the restrictive covenants as attorneys in fact. They signed, the notary block reflects in their individual capacity. Behind their name is the word trustee. That has no legal effect, and we cited several cases that to actually validly execute on behalf of the principal, you have to sign specifically as attorney in fact, and that was not done in this case. So one example is the Etheridge v. Palm Garden. That was a Florida 2nd DCA case of 2022 where they signed as responsible party rather than attorney in fact. And the court was like, okay, even if you have both of those capacities, you have to actually sign as attorney in fact. And that was not done in this case. The restrictive covenants state at the front, at the introductory paragraph, that they are being signed as attorney in fact for the property in the First Edition. Lot B was not in the First Edition, and that still wouldn't be enough. They have to actually sign as attorneys in fact, and that was not done. If you notice on page 30 of the record, the plat for the First Edition states across Lot B, not included in the plat. So that's unequivocally evidenced in the record. To your question of, I think it's a ratification question as to how they treated it. We don't actually have any evidence in the record of how those 8 owners treated this. There's no evidence of their intent. And interestingly, there's really no case law provided by Mr. Hurd or that I found that you can ratify a property interest with anything short of the full formalities of granting an interest. And we cited—
Let me ask you about the bona fide purchaser argument, moving to a different area. Let's assume for a second that that they had the authority to enter into the restrictive covenants and that it's otherwise a valid easement. In your briefing, there's some reference to the bona fide purchaser status and reference to the chain of title, that they're not reflected in the Lot B's chain of title for a good faith purchaser to identify the existence of the easement. Do you feel that you have preserved that argument below? Was that argument adequately presented to the trial court?
I do feel like it's preserved. I don't know that it's determinative in this case, but I do feel like it's preserved. I don't know how much more of a bona fide purchaser you can get than having a partition action seen all the way through. The court orders that the property be conveyed for value to AK Land. So, and that's what we have in this case. And so there was a full partition action resulting in a final judgment ordering the property to be transferred to AK Land for value. And we state that we did pay the value. He paid $145,000, I think, for this property in 2008. But I do want to hit on the ratification aspect because I think.
Well, so my question was whether that argument was presented to the trial court. And maybe you can point me to where it was. In looking through the answer and affirmative defenses and the rest of the record, I just don't see that argument being clearly presented in that way to the trial court.
So actually, Mr. Hurd asked for the trial court to take judicial notice of the partition action in the summary judgment response. So the trial court was fully on notice of those pleadings, and it was presented that AK Land purchased the value for property, purchased the property for value without notice of this easement. So I believe that was preserved in the lower court.
Is that enough to invalidate the easement just in itself?
There was never a valid easement.
Right, but my question is assuming there was.
Assuming there was, I think that the non-use invalidates it, and we go through that a good bit in the briefs, how there was at least a 5-year gap in use where there was no owners that were using it as testified to. So I think that for that reason it's extinguished. I think that it was clear that this was a purchaser for value without notice, that they purchased it pursuant to a court order, and that they were not on notice of any encumbrance. We know that the encumbrance was outside their chain of title. They could not have, AK Land could not have found this alleged easement by a diligent review of the record. So as to the ratification question, I think what you're alluding to when you ask that this is kind of the way that they treated the property. The trial court found that the 8 owners were on constructive notice at the time they entered the trust deed. The trust deed does not reference, first of all, the easement at all. It's just generally we ratify anything that was ever done. And that is not, that's not adequate. That doesn't bring this into the chain of title. That doesn't place anyone else on notice.
Well, one of the things that was done, though, was restrictive covenant, right, that dealt with the use of Lot B for the first edition properties.
I do not believe that is specifically referenced in the trust deed at all. The trust deed just says, we ratify anything and everything y'all have done. It doesn't specifically say the restrictive covenants. It doesn't specifically say.
Well, I'm going off of anything that's ever been done. Why wouldn't that encompass the restrictive covenants that did include the fact that Lot B was for the use of, was
A couple reasons.
to be used by the first edition folks?
One, the constructive notice is not sufficient. Again, ratification we don't really see in a property context, right? Because you have to execute it with all the formalities. You have to identify the property and sign your name to it. And the owners weren't on constructive notice anyway because that had been done outside the chain of title. Also, constructive notice is not sufficient, as this court held in Bach in 1979. It is generally the rule the doctrine of constructive knowledge does not apply to bring about ratification. The principal is charged only on a showing of full knowledge, and not because he had some notice which should have caused him to make inquiry, which would have then brought his attention to it.
When you see reserved in capital letters on the plat, does that mean anything?
It has no legal meaning.
And so none of the properties that were platted on that map had reserved except for this one, which has reserved in capital letters. is that something so your position is that that's something that can fairly be ignored?
I don't think that that puts you on notice of an easement to be granted in the future. I mean, the plat in 1957, the first edition, or the Evergreen plat, yeah, it had reserved, but it could be for what? For another neighborhood, for somebody to buy later?
Well, I think that's the question, right? For what?
For any-
It seems like there at least puts you on notice that something is going on with this particular piece of property. Let's find out what it is.
The fact that it was reserved in 1957 doesn't tell you today, when you buy it in 2018, that there's anything wrong with it after you've conducted a diligent search of the chain of title. You've bought it pursuant to a partition
Well, you
action.
find that it says reserved through your diligent search of the title, right? And that's part of your diligent search. So you see that it says reserved, and does that put you on notice of something that there may be something more that you need to look into?
No, but I agree that you would see that it said reserved, the original plat, but a lot has happened since then, right? You follow, okay, now I see what actually happened, not to mention a partition action. But even if there is some, again, I want to hit on the ratification, because at the time that they signed the trust deed, you have to show actual intent to ratify this specific action at the time that you ratified it, when they signed the trust deed. There is no evidence in the record at all that those 8 owners had knowledge of the easement at the time they signed the trust deed. They couldn't have even had constructive knowledge, because that was, there's an argument about time. I'm not on constructive knowledge of your deeds. Just because they were recorded prior in time to the trust deed, a property owner isn't held to be on constructive knowledge of all recorded items in existence. This was outside the chain of title.
So why do you have this idea in the Marketable Title Act of use? I mean, you wouldn't see that someone has been using a property in a certain way at all in the documents. And so what I'm hearing from you is this is purely a document thing. But also, there's a lot of argument about, well, there's also this thing called use, and if someone has been fairly using an easement all along, then, well, that does encumber the property.
If they meet all the requirements of that MARTA exception, adverse possession was not pled here, so we're not on adverse possession. I do think this can be resolved purely on the documents. And the last point that I want to make on why there was no, when the restrictive covenants with Lot B, beach easement were made, they did not sign as attorneys, in fact. I mean, that's just determinative. They signed as trustees. Okay, so we don't have a valid conveyance there. It's just 2 of them just signing as trustees of what they don't say. So it was not transferred. It wasn't ratified by the trust deed. There's no evidence in the record at all that they knew at the time they signed the trust deed, and constructive knowledge isn't enough, but they weren't on constructive knowledge either, that easement. They didn't even know of that easement. There's no evidence, okay? And then the trial court referenced plaintiffs' exhibits 6, 10, and 14. And so I just briefly want to touch on that after the trust deed, all of these 8 owners are somehow accounted for in subsequent deeds that grant first edition property subject to the restrictive covenants. Again, the ratification has to occur. We don't really ratify property interest, but the ratification has to occur at the time of the trust deed. And I want to point out that 2 of the owners did not even sign those subsequent deeds. Barry and Patricia Allen never signed any first edition deed in the record referencing the covenants. So those subsequent deeds were after the trust deed. It doesn't have anything to do with the intent at the time of the trust deed. And think from a dirt law title perspective, how could we know? I mean, I guess we can just all we ratify anything that's ever happened before. How would that ever put anyone on notice of the chain of title? And so for other things this is a wild grant outside the chain. That would be contrary to our recording statutes, contrary to the whole concept of a chain of title. If you could just generally broadly ratify something without specifically stating what that is.
None of that's in the chain of title for Lot B anyways, right?
I'm sorry?
None of that is in the chain of title for Lot B anyways. When you're doing a diligent search and you're going back through the chain of title, you're not seeing any of that stuff anyways.
Correct. You wouldn't see the easement in the restrictive covenants. You wouldn't see these subsequent deeds to the first edition. But even if that was somehow constructive notice, you're still missing 2 of the 8 signatures, the Allens. And so for that reason, not all the owners joined in any easement, and there was never any easement created. And that is determinative. And so we don't have, the continuous use question, I think, is an interesting one. The statute says, for so long as the easement is used. And so if you've got 5 years when it's not being used, and I appreciate that this court had held in Jacksonville v. Horn, well, it doesn't have to be continuous in that sense. But here you have an actual break in ownership where there was no witnesses. And also in Jacksonville, it speaks a lot about this exception being, for the public. Once the public interest is acquired, it's not easily lost. Here, you have private owners, and it's a different type of use than it would be a road or an underground utility. I mean, they were saying, this is to be used consistently. So I think that break in use would be sufficient. Also, finally, this easement would deprive the owner of any reasonable use. I mean, they just said you can't build a home at all anywhere on the property. It's over an acre. You can't build a seawall, even though the neighbors have seawalls, and that there was testimony that a seawall was needed in this case to actually save the property itself. And so that is not someone that, it's a residential neighborhood, a residential piece of property, and to say that the owner of the property can use it only for the same uses as the easement holders to go to the beach, that is a complete deprivation of reasonable use in this case. So I think the court has a couple of ways to reverse this, but the cleanest, in my opinion, is that there was no easement created.
Thank you, counsel.
Thank you.
And if the clerk would add 2 minutes to each side's argument time. Thank you.
May it please the court, I'm Steve Traylor. I have the pleasure of representing the appellee, Donald Hurd. The court issued a long, detailed, 21-page judgment that addressed all of these issues. In reaching that, the court considered 9 witnesses, 52 exhibits over a 2-day trial, and made detailed factual findings. I want to address first some of the arguments you just heard. I disagree that the whole bona fide purchaser for value issue is preserved. There's not pledged an affirmative defense, nor can it be. The Lot B has the word reserved in all capital letters across it on the face of the plat.
Meaning you think they would lose even if it had been pled?
Your Honor, I believe that argument is not preserved for appeal, but it's incorrect. They're at least on inquiry notice. Cases tell us there's 2 kinds of notice. Constructive notice, which is legal inference that arises from recorded instruments, and implied notice that can be either, actual notice. It can be either express or implied. Implied notice is a legal inference from the facts and circumstances. Here, all of the applicable documents are in fact in the chain of title. That's just an examination that looks at what occurred during the period of time an owner owned the property. When you acquire property and when you sell it, between those 2 points in time, that's a link in the chain of title. All of these instruments are recorded while these owners owned this property. They are, in fact, all in the chain of title. In fact, one of the exhibits at trial, Plaintiff's Exhibit 15, is in the record at 762, is a copy of the general index from Santa Rosa County official records. It shows the warranty deed from the Dodds, and this is a page that pertains to the Allens. That index is alphabetical. The warranty deed from the Dodds, the power of attorney, the restrictive covenants, the trust deed, and a subsequent deed are all on the very same page of that index. It would have been found because it's recorded while they own the property, as that demonstrates.
And how you would get to that again would be a name search, you said?
Yes, sir. If someone was searching to see what occurred, they would go to the general index It's a direct index or reverse index. The names are opposite ways in the reverse. The page identified that's in the record at 762 is the direct index. And you can see all those instruments are recorded during the time where after the Allens acquired an interest in the property from the Dodds.
So are you suggesting that a diligent search would include searching for any other instruments that may have been conveyed or may have involved the owners
Yeah, yes,
by name, so that a diligent search would include looking at everything else that they own and everything else they've done?
Yes, sir. For example, someone may have a judgment against them. That judgment doesn't reference any particular piece of property. It's just a judgment for money. But if it's recorded, if I have a judgment against me and it's recorded while I own a given piece of property, it is in that chain of title to any property that may attach to, notwithstanding the fact that some particular piece of property is not identified in that money judgment.
Is there any legal significance to the word reserved in a plat?
I believe the fact that it says it's reserved would put someone on.
You believe, or there is legal significance to it?
Oh, there is a legal significance, Your Honor.
And what is that? What does reserve mean in dirt law?
Well, what the cases tell us, in fact, one of the cases discussed in the answer brief, in the chain of title section that's talking about notice, it says that implied notice is what arises from the circumstances of the case. Something would trigger you to ask questions, to investigate further. So seeing reserved across the face of this lot on the plat would trigger someone, or should, it's a legal inference that it would
Okay,
trigger
so the
that.
word itself didn't have any particular significance, but if you see something different about that square versus all the other squares on the plat, could be an X, could be a O, could be anything.
Yes, sir.
There's
In fact,
something different, and so that triggers some responsibility.
And in this particular circumstance, as you noted, most of the lots in that Evergreen Shores are identified by numbers. This lot is identified by the letter B. There's another lot on the far end that's identified by the letter A. That has nothing to do with this dispute. I want to circle back to the issue of the trustee. They signed the restrictive covenants. It references a power of attorney in the first paragraph, and it references a recorded power of attorney. But they added the words trustee after their names. The plat of the first edition is also signed by Mr. Townsend and Mr. Allen as trustees. So they platted this property in capacity as trustees in addition to these restrictions as trustees. There's no evidence in the record that demonstrates that they did not have authority to do that. In fact, there's a tight window of 2 months from February 23rd in 1957 to the date of the restricted covenants on April 25th of 1957, where these couples acquire deed from the Dodds. The power of attorney is recorded on March 1. The plat's recorded as trustees on April 9th. And the restrictive covenants those are the dates of those instruments. I believe I misspoke. And then the restricted covenants are dated April 25th. And as the courts notice, these owners proceeded to sell property in the first edition that references these restricted covenants. The court considered a marketing piece that witness Clarice Kell received from Dana Dodd that references this lot being dedicated for beach use. Court noted that the developers sold lots with the representation that this lot's available. There's testimony that owners purchased that with that understanding. In fact, Mr. Hurd testified that he learned of these restrictions when he first bought a piece of property from his grandfather in 1980. All the witnesses testified to use of the beach. The court considered other instruments that are recorded whereby some of these owners either granted deeds in the first edition with reference to the restricted covenants. Those are accounted for in Plaintiff's Exhibit 15. With respect to one of the Allens, Patricia Allen, she and Barry Allen bought property in the first edition by way of a deed that references these restrictions. But certainly, any grantor is stopped from denying the things in a deed that they grant, as these owners would have been with these deeds that they granted with reference to the restricted covenants.
Let me ask you to shift gears and talk to us about whether or not, assuming it's all valid and this easement is as the trial court found, tell us why it doesn't deprive them of any reasonable use of the property.
Your Honor, what the court's judgment says is they can't do two things. They can't do three things. They can't build a house, they can't build a seawall, they can't do something that interferes with the use of the property for beach activities. Court noted that AK Land Title, its owners, its employees, guests can use this property for beach privileges. The court noted they can build a pavilion, volleyball court. They can do all these same activities that the lot is.
And why couldn't they build a house? I mean, it's a big lot, it's over an acre, and it seems like, you know, you go to the beach in the Panhandle and you have access on a boardwalk and there are houses on each side and things are pretty tight.
Yes.
And so that a house on a quarter acre, a house on a half acre on this lot would seem like, okay, this house is up in the wooded portion, upland.
Yes.
And you still have all the beach stuff going on beachside, you can still have a house. Why isn't that workable?
Your Honor, one of the arguments that AK Land Title advanced was that it's all or nothing,
Say it again?
that it's all or nothing.
Yeah.
If the beach,
Okay.
if it's encumbered by easement for beach activities, the entire lot. AK could have argued that very argument. Of course, the east 27 feet of this lot is also encumbered by drainage easement, but AK could have made that very argument and argued that some upland portion would not have interfered. In fact, the judgment acknowledges AK Land Title's argument and says the court agrees. That was the argument that AK made, that if it's there, it encumbers everything. The trust.
Right, so the trial court agrees. Does it not create a problem that they have this piece of property that is, arguably like a public park now that they have to pay the taxes on, and they have to pay the maintenance for, and they have to deal with liability insurance and things like that for these other people, but they're unable to do really anything else with it?
Your Honor, in fact, in the partition action, that judgment notes that Lena Allen, who's AK Land Title's grantor, had in fact paid the taxes for 17 years. And the distribution of those proceeds reimbursed her for that. But the land cannot be used by the public, and that's a distinction here. If it could be used by the public, then there's a statute that provides some immunity for an owner that makes his land available to the public. But that's not the case here. To make this available to the public would be greatly expanded, and I suggest overburdening the scope of the easement.
So who wants to own a piece of property that they have to pay the taxes for and insure and maintain so that a neighborhood can use it for beach access? I mean, does it realistically still give them the ability to use this piece of property for anything else?
Well, it arguably nothing inconsistent, certainly, with that. But there are, the court, I believe the judgment even suggests that this property could be sold to some owner in the first edition, or some group of owners that may have an interest in becoming the owner or setting up an HOA. It's regrettable that there wasn't an HOA, but that's not what these owners did, because that's typically what would be done when there's common areas and you have mechanisms for doing those very things. But with respect to that, I suggest AK's land titles remedies lay elsewhere. It lay with going back to its grantor, or, you know, something besides depriving Mr. Hurd and any other owner in the subdivision with the rights that they had long held and long used. The trustee found that
Well, what does that look like? Can you elaborate on that?
I'm sorry, what?
You're suggesting there's an alternative remedy. Tell us what that is.
And it's cited in the last page of the answer brief. Asked Mr. Hurd at trial, Mr. Avant, AK's witness, its manager, if he had, and I'm paraphrasing certainly, if he had pursued going back against his grantor. And he testified to the fact that he got with the title insurance company about that. I don't know what transpired. He didn't elaborate, but his remedies lay elsewhere. His remedy is not in depriving these owners of their rights because he bought a piece of property that's encumbered by a beach easement. The trust deed speaks to ratification, approval, and confirmation. I submit those are three different things that are somewhat similar with respect to approval and confirmation. I submit by using all three of those words, the trust deed intended to say, whatever Mr. Allen and Mr. Forrest have done, we're okay with it. Ratification typically applies to some unauthorized act. There's no evidence that they weren't authorized. In fact, the plat, as I mentioned, being signed as trustee suggests that they were in fact trustees and were acting pursuant to some trust arrangement or agreement. This court's decision in Bach versus Florida State Board of Dentistry, 1979 case, is quoting the Oxford Lakeline versus First National Bank. It's a 1898 Florida Supreme Court case, and it's discussing ratification. And it mentions several circumstances. One of that is the last one that's cited in this court's decision, quoting Oxford, is that the person ratifying intended to adopt the unauthorized act at all events under whatever circumstances. So I suggest that ratification would pertain to some unauthorized act, whereas approval tends to denote that they're agreeing, they're acquiescing, they're validating. Confirming suggests that they're acknowledging or verifying something. So by using all three of those terms, and ratification is certainly a legal term of art that's distinct from approved or confirmed, I suggest that all of the owners is saying, whatever these two guys did, we're okay with it. And their subsequent buying and selling lots, marketing lots with this beach privileges as amenity demonstrates, and additionally that they absolutely were acting with authority and that these owners all acknowledged and agreed to that. See, I'm out of time. I'll stop.
Thank you, Mr. Trev.
Thank you.
Ms. Scholl?
Thank you, Your Honor. Briefly, so actually the plaintiff advanced the argument of all or nothing. That was as early back as the complaint when they asked for a temporary and permanent injunction preventing AK Land from building a house on the property and saying that, you know, just because we only use part of it doesn't preserve the whole easement. So that was the argument that AK Land was kind of forced to deal with. Hurd states that he first learned about these restrictions in the 1980s. Well, then why wasn't he concerned when it didn't say subject to the restrictions on any of his deeds? And that's at record 1042 and 696. Reserved, even if the word reserved, again, Just because it was reserved for some purpose in 1957 doesn't mean that you're on notice now in 2018 as following a partition action and the trial court scrutiny. But let's say it did. Let's say that that put AK Land on notice that they need to go and look for something. They could not have found it. No diligent search. And we even had an expert affidavit at Record Site 132 that said a search didn't turn this up. No diligent search could have turned this up. So just because you are even on notice that you need to go and look for something, that doesn't mean wild deeds outside the chain of title. I don't know who searches the grantee index just periodically for their own name, but so, okay, it's on the same
You may
page.
briefly conclude where.
Oh, Your Honor,
over
yes,
time.
thank you. The marketing piece has no legal effect. The easement never attached to the property. It was not able to be found. And for this reason, because not all Lot B owners made this representation as stated in Burdine, that it has to be the same formalities, there was no easement ever created, and for that reason, the judgment should be reversed. And I appreciate your court's time in allowing us extra time.
Thank you, counsel.